nature of this proceeding. Let's start. Article 226 and 227 of the Constitution comprise of civil, criminal as well as other proceedings. Civil proceeding which is not defined either in the Constitution or the General Clauses Act would cover all proceedings in which a party asserts the existence of a civil right conferred by the civil law or by statute and claims relief for breach thereof, where a revenue authority seeks to levy tax or threatens action in purported exercise of powers conferred by an act relating to revenue. The primary impact of such an act or threat is on the civil right of the party aggrieved, and when a relief is claimed in that behalf, it is a civil proceeding, even if relief is claimed not in a suit but by resort to this article. Civil proceeding is one in which a person seeks to enforce an alleged infringement of the civil rights against another person or the state, and which, if the claim is proved, would result in the declaration express or implied of the right claimed and relief, such as payment of debt, damages, compensation, delivery of a specific property, enforcement of personal rights, determination of status, etc. Thus, whether the proceedings are civil or not depends upon the nature of the right violated and the appropriate relief which may be claimed, and not upon the nature of the tribunal which is invested with authority to grant relief. Criminal proceeding, on the other hand, is one which, if carried to its conclusion, may result in the imposition of sentences such as death, imprisonment, fine, or forfeiture of property, if also included proceedings in which orders in the large interest of the state are passed to prevent apprehended breach of the peace or to bind down persons who are danger to the maintenance of peace and order, or are aimed at preventing vagrancy. But the whole area of proceedings which reach the High Courts is not exhausted by classifying the proceeding as civil or criminal. There are certain proceedings which may be regarded as neither civil nor criminal, for instance, proceeding for contempt of court and for exercise of disciplinary jurisdiction against lawyers or other professionals may not fall within the classification of proceedings civil or criminal, and which may therefore be included in the expression other proceeding finding place in Article 132 of the Constitution. Proceeding under Article 133 must be regarded as a civil proceeding if the original proceeding concerned civil rights. Proceedings before the revenue authorities regarding recovery, discharge of debt were concerned with civil rights, and as such the same were civil proceedings. Accordingly, petition before the High Court challenging orders passed in the said proceedings must also be regarded as civil proceedings. Framers of the Constitution were aware that a new jurisdiction was being conferred on the High Courts under Article 226, and this jurisdiction would often result in decisions affecting civil rights, and the need to provide for appeals to the Supreme Court from the determination of the High Courts must have been equally obvious. The right of appeal under Article 133 having been expressed in general words, no exception not mentioned in the article be implied. Petition filed by a company for a writ of certiorari under Article 226 for quashing part of an industrial award is a proceeding independent of the dispute between the parties. Such a writ proceeding is not an interlocutory proceeding, nor is the order dismissing it an interlocutory order levying any question raised in the writ petition to be determined at any later stage. Once the High Court dismissed the writ petition, the controversy between the parties raised therein is finally determined and therefore comes to an end. Thus, order of High Court dismissing writ petition against the interlocutory order of the Industrial Tribunal is a final order within the meaning of Article 133 within bracket 1, and that an appeal lay therefrom to the Supreme Court. Question regarding nature of proceedings arose in a different context. Section 162 CRPC bars the use of any statement made before a police officer in the course of an investigation, under whether recorded in a police diary or otherwise, but this bar is applicable only where such a statement is sought to be used at any inquiry or trial in respect of any offence under investigation at the time when such a statement was made. If the statement made before a police officer in the course of an investigation is sought to be used in any respect of in any proceeding other than an inquiry or trial, or even at any inquiry or trial, but in respect of an offence other than that which was under investigation at the time when such a statement was made, the bar of section 162 CRPC would not be attracted. This bar has no applicable in a civil proceeding or in a proceeding under Article 32 or 226 of the Constitution, and a statement made before a police officer in the course of investigation can be used as evidence in such proceeding provided it is otherwise relevant. The proceeding in a writ petition under Article 32 of the Constitution filed by the petitioners for enforcing their fundamental rights under Article 221, and it is neither an inquiry nor a trial in respect of any offence. A statement made before a police officer during investigation can be produced and used in evidence in a writ petition under Article 32 oblique 226 and Section 162 CRPC cannot be urged as a bar against its production or use. Stop. Thank you.